I'm Clare Apana of Malamaka Kaniloa, and today we have the pleasure of having Tim Mentz, the historian of Standing Rock, with us today. And I'm going to let each one of these gentlemen introduce themselves because we're in for a real treat. And so we'll start here with Kaniloa.
Aloha, my name is Kaniloa Kamaunu. I am with Malamaka Kaniloa. I am on the island of Maui. And yeah.
Hello, my name is Tim Mentz Sr., member of the Standing Rock Sioux tribe from North and South Dakota.
Palikapu Dedman, the Petty Defense Fund. I'm from the Big Island, raised in Kau. And I'm here to really greet Tim. I asked him, they invited him to deal with our burials. We've been dealing with burials from Honokahua on this island of Maui and every island. The state has their own attitude about how they treat native burials. So I'm looking at how the tribes of in Standing Rock and how they deal with the burials.
We are actually here gathered together because we've been in a contested case for the last almost a year now, or a couple of years now, with the Grand Wailea Resort, who is actually owned by Blackstone, which is an international company. And the reason we're in there is because the area of the Grand Wailea, the grounds that they're on, are actually on burial grounds, graveyard basically. And so we got together this weekend, and brother here came to join us to stand with us and protest against the Grand Wailea and their thoughts of expanding. So what that means for us is the possibility of them disturbing more of our iwi kupuna, which is our ancestral bones, and not only that, but a historic area, and it's right on a beautiful ocean side, which has also been damaged to a certain point. And so we got it together with us as Malamaka Kaniloa, Pele Defense Fund, and Ho'oponopono Makena, which is Ashford de Lima, got together, put up a contested case, became interveners. And so we were, with all what's going on, we had the opportunity to have someone that had the knowledge of the federal law, which talks about the burial laws. And on the federal, because we don't get to deal with that. We only deal with the county and the state. But to hear and given the information that we did receive, I think is really helpful for us. It gives us an opportunity to strategize and, hopefully, win the opportunity to protect our iwi kupuna. So,
And we're in court next week.
yeah, it's like join us. We're going to be in court next week again to go over this.
I would like to start out by asking, in dealing with the burials in Dakota land, getting the states to respect the tribes and the possession of iwis that the tribe had to get back from the state, we'd like to know how and the process that achieves that. And that's what we're trying to get here. So I'm wondering if did lobbying your senators, your representatives in Washington, D.C. Was part of making these NAGPRA laws and getting the tribes to be responsible for their iwi or their bones? Or was it lobbying as an angle to get their lobbying, meaning more of a state or the tribes all come together and look for how you take that responsibility on? Or is it litigation? Do you use a lawsuit to instigate the turning over or the mines to turn over or the rights back to the tribes on burials? We have a problem here that there's a NAGPRA Act that has Hawaiians on it, but the state won't accept it. So I'm wondering how you take that responsibility back to your tribe. So that's a question I have for you.
Well, thank you, Polly. I think it's a combination of a lot of things, and as for us within North and South Dakota, we're members of what we call the Ocheti Shakoi. We're called the Seven Campfires. That's what that interpretation would be. And we're a group of seven distinct tribes that have been always unified in relation to how we had movement through a vast area in central United States. Basically, 66 million acres is what we claimed as our homeland. And I think for the purposes of what we're discussing today, it's important to understand where your homelands are at and how you assert that claim. And we did that immediately when we started to get from 1978, the American Indian Religious Freedom Act, opened a door for us to step out to start talking about these. And I'll say for the purposes of today, it's a hard subject to talk about our relatives that have been placed in the ground in a very special ceremonial way. They have been placed within what we call Unchimaka, our grandmother earth. And they're supposed to be there forever. They're part of the earth. They go back to part of the earth. And so what we did, we started to educate our legislative people, our congressional people, particularly the senators and particularly the congressional people, mainly of the House and the Senate, on what it meant for us to not only exert our authority over our relatives within a certain defined area, but more importantly, we had to explain to them why that purpose was important to us. And we referred to that purpose as our youth, the ones that are coming yet, and the ones that are going to be coming in the future, that they have to have an understanding. So you need to be able to understand that when we start talking about this in a certain way. And of course, we talk about these things very importantly in a certain way because we were brought up with that. So what we did was we immediately went to the congressional people. We had North Dakota and South Dakota congressional people that were really sensitive to it. And the reason they were, from the 60s going into the 70s, unearthing of human remains was happening all over. I could only say it's probably similar to what is occurring here today. And it was our efforts of not only exerting authority, because a lot of times the states say, well, we have jurisdiction and we'll take possession of that. We challenged it immediately. So there was a combination of, we had to go to court. We had to challenge their authority because they were saying those belong to us, so we have to put them in the museum to study. And their big issue was we need to define who they belong to. Who's the cultural affiliation? And that's something that you may run into here. But what we did was then, hearing that from the states, we went back on the congressional people saying that we don't have to prove who we are. We already know who we are. You need to give that back to us, the ones that you have taken from the ground. And so what we did was we educated our congressional people. And that was a very tough road at the time, going into the mid-1980s. From 85 to 90, those 5 years it was an effort of all the 7 bands of Ocheti Shakoi, because we had a vast area that we had responsibility for, because our people were in those areas and we left our relatives there. So that was important to us. So it made us come together to unify and talk with one voice. And once we went up on the hill, we started to talk to them with one voice. We started to get their attention, because once we started to do that, our purpose was, and we knew what we had to do, use the congressional people to influence the state legislative people in order for them to understand you have a state law that does not protect our people. Matter of fact, you take it under state law saying it's their right to retain disposition. Disposition was the main factor of what created NAGPRA, the right of possession, disposition, and that right. So as we were moving And everywhere we went, we had to educate the important people that was basically the legal people had to understand why we were asking them to argue this important piece of legislation for us. And in doing that, we started to educate the surrounding communities. One of the things that we had to do is educate our own people, and that may have to be something here. But as far as how you take that step, lately here in the last 20 years, in NAGPRA, it started November 16th, 1990, Congress enacted NAGPRA, Native American Graves Protection and Repatriation Act. Within that process, they also have Section 3, that's intentional excavation. And that was the really hard part of approaching NAGPRA in relation to how we wanted it structured, because we do not agree with anybody intentionally digging up and unearthing our relatives. And that happens all over today yet. So understanding the state's relationship with the process that the tribes had, they started to understand that they did not have responsibility or the authority to keep our relatives. So it wasn't until 2001 that we started to take all our relatives out of the museums from the state holdings. A lot of the museums that are in the states also had human remains. We had to approach them also. All the universities within the United States have collections. They call them collections, and they keep our relatives. But what's important about it is we have to make a concerted effort to be unified. And once we do that, we created what we had as a North Dakota Intertribal Reinternment Committee, that basically we went after all our relatives. That was the first thing we went after, all their burial goods, all the cultural items, the funerary objects, everything that was within that burial that they excavated, we had them returned. So the whole state of North Dakota, with all those universities, museums, and the SHPO, they don't have no more human remains. So then we went after South Dakota. So we're sitting there that we exerted that responsibility and authority, and everybody can do that that's listed in NAGPRA. That includes the Native Hawaiians. So, we're here to help. We want to assist. That's why I came down. I want to make sure that I can do the best I can and say the right things in relation to having an important role and showing that you can do it. It's a matter of being unified within this structure. But maybe if you could share with us those types of processes.
Well, so my point of view is different than Uncle Pali's, and it's only because of what I've learned. But you're correct that the process that the state is actually using is basically what you were saying about them claiming the rights to the burials and to our EV. They make certain decisions, what they call inadvertent. So just to clarify what an inadvertent is. So basically inadvertent is kind of an after the fact. So when the archaeologist does their supposedly data research and they come to the conclusion that they're not going to find anything here significant, whether it be our bones or whether it be some kind of historical site or artifacts. And once they put that into their paperwork and reports and submit that, and so anything after that report becomes what they consider inadvertent. They actually state in one of the definitions that that the bones of our ancestors are basically important to the culture, and that it's important to us. But yet, the state still takes away that still takes charge of the EV, and we get stuck all the time trying to fight the state. We're not only fighting the developers, but we find ourselves fighting the state and county to be able to go and protect. And unless like our group and like with Polly, Uncle Polly, from the board, if you don't show up and show some kind of force and presence, a lot of this just gets swept under the rug. So, how else? I guess my question to you is, if NAGWA doesn't apply, how would you approach our situation? Because that's kind of what happens with us. Because like you have set tribal lands, and I guess for us, DHHL would be in charge of our tribal lands. I mean, the Department of Hawaiian Homelands, but a lot of us not on Hawaiian Homelands, and a lot of our EV is not on Hawaiian Homelands. So I don't know. What is your view maybe with that kind of complexity? Because Hawaii is complex.
Yeah. So let me just say that we actually ran into that in 1989. The state of North Dakota was exerting that authority for a private individual, and they unearthed, I believe it was 4 of our relatives. And so it made us really think about not only the process, but also when he was actually building a road. He was upgrading his road into his place, and it was a 2.5 mile road in the central part of North Dakota on private land. And most of the private land, they have to adhere to state law. So whatever the state, whatever you have a burial code, or North Dakota has a burial code within their state law, century code. And so what we did was we started to focus in on when prior to NAGPRA being enacted in 1990, and this was 89 when we ran into this situation, we realized then that private lands was going to be a problem. And our elders got together and we said, well, how can we deal with that when it's under a state law jurisdiction, and private landowner is saying, well, that's on my property, I get to keep the human remains. So it was a problem at that time. So we wanted insertion into the NAGPRA law was Section 3, what I brought up. Intentional excavation, or in this case, we wanted to also, address the inadvertent discoveries. So one of the things that we did was we got that included into the NAGPRA legislation. Now, knowing that there was those types of things that were occurring, like on private lands and on state lands, we have another law, and I think this is where it'll play into your question here, and I'll answer it by. In 1966, the National Historic Preservation Act was enacted, and from 1966 all the way until 1992. Soon as NAGPRA was enacted in November 16, 1990, we immediately turned our attention to the National Historic Preservation Act. And this is important to understand, because this is how we got around this issue of private lands. What we did was we changed and amended the National Historic Preservation Act to include the tribes, and in that definition includes Native Hawaiians. That we amended it, that we have the ability, and now we want to assert our authority under the 92 amendments, that we take jurisdiction and have that same level of jurisdiction that the state has with their state historic preservation officer. So what we did was Congress agreed with us and enacted the 92 amendments, and basically Section 101 D6B was an issue of sacred sites and burials, but Section 101 D6 is the section that allows an Indian tribe, a Native Hawaiian, or Alaska Native to get control of the process within a defined homeland area. And when I was coming down here, I was thinking about that, because I think in Hawaii, Native Hawaii, even on any of the islands, nobody has challenged that state historic preservation officer. So the 1992 amendments to the National Historic Preservation Act basically, in a nutshell, says that, we're amending the responsibilities of the state historic preservation officer, because once you do that, you're now getting into how archaeology gets out there to look at these areas. And that's where the start is. And that's where we found the problem, was the state archaeologist was going out there and saying, okay, wait, now we have this burial here. We're taking possession under state law, so we're going to take possession of the human remains. While in the process of amending the 1992 amendments to the National Historic Preservation Act, we included two options. One, within a defined boundary, we created the Tribal Historic Preservation Act officer, that has the same authority within that boundary as the State Historic Preservation Officer. And outside of our tribal lands, our tribal reservations, that boundary, unlike Standing Rock, is 2.3 million acres. So we have our own Tribal Historic Preservation Officer. Same authority as the SHPD. We took that authority away from the states of them exerting authority within this boundary, but also within our defined homeland. So when we set up our office in 1996, we said, the National Park Service said, well, what's your defined boundary? What boundary are you saying that you have authority over in jurisdiction? It was the 66 million acres. It was 66 million acres. That's basically our 1851 treaty. So it's a little different from Hawaii and this issue here with the Native Hawaiians. But the issue, getting back to the state in relation to how private landowners were trying to exert authority, what we did was outside the reservation boundaries in any state. It didn't matter if it was state land, private land, church lands, any type of lands. Regardless, we put in a clause, regardless of location, the tribes have a right to disposition of human remains. That's how we got around it. So now the states, soon as they enacted the 92 amendments, we went after the state legislature and the state government. Okay, you need to comply, and you need to readjust your state law in order to comply with the 92 amendments to the National Historic Preservation Act. And so we are taking possession. So we codified, we changed the state law, we made a reburial law within the state structure, and the state passed it, that all human remains, regardless of what location, whether it's private land, church land, state land, anything other than federal, anything non-federal land, the tribes have a right to take possession. And that's how we address the issue that you are talking about right now. We used the 92 amendments to the National Historic Preservation Act. And one more thing I'll add is that those two acts, they call them the sister acts. They comply with each other. So you got to work both of those laws at the same time in order for you to control disposition of human remains. And one of the things that you as Native Hawaiians have is the ability to establish that person that's going to have the equal setting of a state historic preservation officer, because that's where we had the problems. Was the state's historical society and the state SHPD officer was taking control of everything outside federal lands or tribal reservations. So the 92 amendments is somewhere that you would be able to look at it. And that's what we were talking about, Polly, that, and that's something that you mentioned, that maybe that's something that you would take a look at. And this is kind of why we're down here now, to discuss these things with you.
Yes, in listening to how you were going about it, sort of like a plan or an angle about NAGPRA and how you would get it into the state to have the language of it. You know, we only became a state in '59. I mean, that's just like yesterday. I think I really thought the state was going to be the answer. I really stood there, and I think what they do is they hand out crumbs, make you feel okay, but in the long run, you ain't get nowhere. And how long is a Hawaiian, and any Hawaiian, challenged or tried to go the route of the NAGPRA? Nobody. You know, and when you come with that, you would get comments about it from people who don't know nothing about it. All they know is their struggles and what they get stuck in. So they start reaching out to look into me, into history books, which is fine, but so did the tribes. They got history books. That never really helped them. It was them and their aggressiveness about who they are. They know their history. You don't got to dig it up again. I like to know how you're going to treat me today. Not about yesterday, because I know what you did yesterday. Why are you repeating yesterday? Today is what I like to know. It shouldn't be like that today, how you treated yesterday. So I just see that there's this problem in Hawaii that I've learned throughout all these years dealing with the state, that the federal government has got a bigger hand and a bigger hammer to make a difference for us. I just can't keep going round and round and never get any efforts. You don't get anywhere. And when I'm saying anywhere, it's not a piecemeal because you got fixed here and they screw up 10 other places. You know, you got to make something that covers the other 10 places. You know, it's got to be a whole blanket thing, like the way of treating natives. And we're not Kauaians or Molokians or Mauians, and we get this real Western attitude about boundary lines, you know, especially on ourselves. So I just think the uniting that you say, that's a big part. That's a problem in Hawaii. Is to get all the Hawaiians to one. They're very comfortable living some different way, and that's the problem we have. So, no, I really want to know how and try to do the lobbying efforts to make it a big deal. As I thought earlier, that you almost gotta leave people behind. You gotta almost leave and go someplace and come back with the goodie. You know, it's gotta come from DC, and everything stops in Hawaii. We're the 50th flag, so we're the last guy. And if we never learn from the other 49s how to get to first base, second base, third base, then we'll always be stuck in a dugout, man. Because I'm just saying that that's how we have to be. We have to take what works, and if it's the same enemy we fight, then how'd you get there? Winning, or what little wins or big wins, that's what we should try to accomplish. So I really think that the lead, dealing with the enemy, and experience of dealing with them more than we do, since our state was in '59, the real attitude about new law and all that, we got to look at the federal side of how they treat indigenous people up there and what you do to get more of your responsibility back to yourselves and claim more of that. We got to do that too. We're not even there yet. And they know that. And they know if NAGPRA or the feds would come taking over. I was picturing that we'd have a federal office dealing with barrels in a federal building. So anybody that come up with barrels shipped to a state would have to contact the federal building or the federal office of dealing with Hawaiian barrels, and not the state do everything, because that's the problem we had. Sure.
So going off of what Uncle Polly was saying, and you know, we actually had this discussion with SHPD, because when we investigated SHPD, so SHPD was created under one federal mandate, which is the NAGPRA. So when we asked about that, I know Claire asked about it several times, how does it apply? The administrator or the director told us that it doesn't apply. Because we were trying to ask him, shouldn't those laws apply? Because they were mandated and they get federal funding to run that office, and he actually was hired because of his work with the Navajo Nation. I believe.
Oregon.
Oh, in Oregon. So he was hired because he was already working in that, and he was supposed to, I guess, know how to apply the NAGPRA. But we have been asking, like what Uncle was saying, and we tried to push them together. They say, "Oh, it doesn't apply. It doesn't apply." And I think because, like I was asking you earlier about, the lands that, how they look at the land is what they're saying. Yeah. It doesn't fall on NAGPRA because it's not on federal lands. But that was a good, to know that there is a part in that NAGPRA law which applies to private lands that you guys claimed. So, we were talking about going after, we wanted to basically go and sue the State Historic Preservation Department for not applying those laws. Well, I don't know if that's because when we look at everything, what happens, the process here is, okay, so a developer applies for, a permit to the county, to do grubbing and grading, even like in a heavily sensitive area. So the county takes their part, they send that permit to the State Historic Preservation, which is supposed to go and investigate, check the boxes. Right, but we came to find out a couple years ago when the administrator came to testify in front of the county council that he basically said that, well, we don't have the money and we don't have the manpower, so he just signs off on it. And so we kind of like, well, so how do we get any protection? And that's when we started talking about the NAGPRA law, and he kind of turned us down and said, no, that doesn't apply. And so, So I guess to kind of go with Uncle Paulie, so what would be like that's what our process right now, they're saying that doesn't apply. So, but with, of course, what you just said with that one section in there, but what would you, going with Uncle Paulie, so what would be the process, because we want to actually, we kind of looked at it, that's the only people we can sue because they're the ones okaying all the permits. And then the developer comes along and says, well, we got our permits, they certified our permits, and then the county says, well, the State Historic Preservation had no problem with it. So I don't know what might be your view on that.
Mm-hmm. Well, I think you got a couple options there. One, you do know that there is a national office, a national federal office that deals with specifically NAGPRA. There's two individuals there that when we started with in 1990, that's how long I've known these guys, and I've stepped away a little bit. But in the last 10 years, I've been involved with it. I stepped back and let the younger ones take over what I was doing, and that was burying our relatives when they were unearthed, our inadvertent discoveries. But one of the things that I did in order to let the people understand, first I started with our communities on the reservation, was I invited the National NAGPRA office to do training, technical training, and there's where we start posing all these certain questions that we had. Where does it apply? When does it apply? Who has the responsibility to see the authority and the responsibility of NAGPRA be administered fairly the way Congress intended? And the gentleman, Francis McManaman, was at that time ahead of the NAGPRA program. And he had another individual that was actually ended up doing the regulations, and they became final in 1995, was Tim McEwen. He is very well versed in not only NAGPRA and how it applies, but he helped write the regulations. And the second option that I think may and may not apply here, but I think you need to research this, is so we changed the regulations, 43 CFR 10, Part 10. That's the regulations that implements the statutory law of NAGPRA, Native American Graves Protection Repatriation. What we did was we had that, those went actually final, I believe, in 98, the regulations 43 CFR 10. But when we came to 2001, I believe it was 2000 or 2001, one of those years or in that area, we amended the regulations to address the issue of private lands, state lands within our responsibility, within our jurisdiction, within our reservation boundaries. Because all the reservations within the United States are checkerboarded. So even though you have a very defined, articulated boundary of your reservation, like for instance Standing Rock, we still have a lot of private lands. We have the state in there with church lands. There is some state land within the Standing Rock Reservation. So we amended it by saying, okay, we need a federal agency to oversee the permitting of any projects, any development that is applying or occurring on private lands or state lands or church lands. And what we wanted to have changed is that federal agency at that time, and it's today, this is what it is the Bureau of Indian Affairs is basically the federal agency under the Department of Interior that manages the lands on the Standing Rock Reservation, basically all the federal land. And that is an ownership of either the tribe or what they call allotted landowners. Or like myself, I'm a allotted landowner. They call us that, but I own land within Standing Rock, and that's federal. It's what they call federal trust land. So what we wanted was the same application that applied to those federal lands within our reservation boundary applies also unilaterally to private lands, church lands, state lands. So we amended it by saying, okay, we identified the federal agency. We want the Bureau of Indian Affairs, since they're the federal land managing agency, to be the permitting agency on all private lands, all church lands, anything non-federal within the reservation boundary. The Bureau of Indian Affairs takes over and they exert authority for the tribe. And for me, I'm a member, and they apply NAGPRA on those lands. So if there is a county project going on, there's a state project going on, whether it's a road or any type of state funded that has nothing to do with the federal government or the county government has their own funding, they still have to apply NAGPRA unilaterally on their project. And see, that's where the 92 amendments come in now. So now we have not only NHPA, where it requires consultation, NAGPRA requires consultation on Section 3. So if nobody's talking to you, nobody's following the law. So my first option, I'm saying maybe you should do that. Get the National NAGPRA Committee to come here and they tell you what is the role of NAGPRA within an area that does not have federal lands. Let's say an example. We already know what the role is on federal lands within the state of Hawaii and those certain areas that you mentioned. But majority of what you're talking about is the non-federal lands. And we used that component. So it's in the regulations, and it applies to every state. So I don't know why Hawaii is telling you that that is not even close to what the regulations say. So the question would be here is, what federal agency within the state of Hawaii, with any one of the islands, what federal agency can you identify that will have that responsibility under the regulations of 43 CFR 10 that has to be basically the permitting agency for any development on non-federal land? That would be the question. And the reason I bring up option 2 is they will help you establish that. So we pulled in that national office, NAGPRA office. That's how we got the regulations changed. And that's how now all, whether it's Indian tribes or Native Hawaiians or Alaska Natives, they all have that ability. Alaska has exerted that authority now on private lands up there. And so that's something that I could. Just
a quick question going off of what you were saying. So, for us, I'm looking at SHPD. So SHPD is actually mandated under the federal. So would they be the office? That's the question.
Yep. Yes, that would be the office. And the thing about it, when we approach Bureau of Indian Affairs, now they're within our reservation boundaries. They're a federal agency. They did not want that authority. They did not want that responsibility of telling that non-Indian person. That's basically what it was. It was a non-Indian that had private land there saying, hey, we're going to have to come in there. And by the way, you got to get a permit from us if you want that road project to go in there. And that private landowner is saying, well, I got no federal money involved with this. There's nothing federal about this. Yeah, but the regulations changed, and we are actually the permitting agency for your project. So either you get our permit, and when you give us that application for the permit, we have to consult with the Standing Rock Sioux tribe. That's no different than applying it here. So I really think it would be really in your interest to have an organization, because under NAGPRA and NHPA, the 92 Amendment says a Native Hawaiian organization. It does, yeah. It doesn't say specifically. They did at one time have one specific in there, but I understand that they don't operate now. So if you do that, you have then now established your standing within the law itself. And I'm just saying that because it's never been tested here yet. So a lot of us have been watching because we've been watching kind of some of the case law that comes out of here, and we've used that over the years back up in the States, because we all look for each other. Alaska had some case law up there that helped us and benefited us and helping us do certain things on the lands. And mainly that was the rights of possession, the disposition of your relatives. And that's what I think the overall setting, if you approach them like that, that's really a humanistic, really value system that we all share. I don't care if you're not native or indigenous, if you're European, whatever you are, you do have a value system that says your relatives are important. The problem with that is the ones that came here, they're saying that that's not important to us or to the Native Hawaiians because they're not a part of that. So they turn around, walk away the next day. They go back off to their home, and they're not living here. They're not living in your, as you say, the cultural and the spiritual understanding of your people. And so there's a breakdown in that. But using that federal process, and that's what we used in amending 43 CFR 10, forcing BIA to take that responsibility on private lands. And so it's like that on every reservation now. Every reservation in the whole United States now can address private lands. So now the issue is outside our reservation boundaries. Okay. Same thing. It's the same thing. And that's why I'm bringing up the 92 amendments, because in there it says regardless of location. Now nobody from the states to any corporations, nobody has challenged that. So that's still in there yet. Regardless of location, you have a right not only to identify that it's important to you, but you also have the right of disposition. It's a Fifth Amendment taking issue. That's what NAGPRA was all about. It was a Fifth Amendment taking issue. In this case, we're not talking money though. We're just saying, hey, give us our relatives back. So
what would be sorry, Uncle. So where would we go if we're having problems with that federal, representative, which is SHPD, which we are having problems even to get contested cases? Where would you advise us to look? Is there like a place that we can actually go that can interact and force them to apply the NAGPRA laws? 'Cause they're not applying it. And so is there a place that we can go if we can't get justice from them, or for them to do their due diligence? Where should we look? Where would you suggest that we look?
Yeah, and so we ran into that also. And one of the things that immediately our legal counsel said was, okay, bring in the National NAGPRA office. Have them do the training. And then that helps you create standing should you go to court, that you already have been advised on how you implement it. And that was one way that we approached it. And the thing about that was, though, is that we wanted to make sure that we were doing it right. So what we did was we looked at the other areas in relation to how other states were doing it. So it's a combination of not only the state law and how you approach them, but also it's the federal authority. So once we did that with bringing in the National NAGPRA office, If they didn't comply, guess who they turned them on to? Department of Justice. So now DOJ steps in and they bring that whole shroud of not only law enforcement, but that enforcement authority to say if you're not complying, that they'll be filing charges. So we use DOJ to go after a lot of states. And that was because all of our tribes and all the other adjacent states were seeing that what we were doing in North and South Dakota with the North Dakota and Tribal Reinternment Committee. And let me just say that North Dakota and Tribal Reinternment Committee was something that, we have 5 tribes in North Dakota and there's 9 in South Dakota. And we created this because 3 of the 9 while there's 5, that's 14 tribes altogether. 3 of the 14 were tribes that were not part of Oceti Shakowin, our tribes, that 7 Campfires that I belong to. So there was that group, and there was 3 other tribes that we basically warred with, and we had land disputes going back 500, 700, 900 years, but what we did was at that time, we came together through our spiritual leaders. So we brought one from each of those reservations. And of course, we all had our disagreements, but when it came to human remains, we just gelled, we became one. And that's where probably what you're talking about. You walk with one tribe, yeah, you are gonna have a hard time. And like what I was explaining today, my grandpa was standing there one time and he had some sticks and he came in this meeting and we were talking about unity. We need to all band together and walk in one voice. And guess what he did? He picked up a little stick, about maybe 8 inches, 10 inches. And it was about the size of a pencil. And he said, I want to show you something, my relatives. He took it, snapped it right in half, real easy. And this was with the 7 Campfires, these 7 bands, all of us were trying to get back together. And so he said, let me take 7 of them now. He took 7 of them and they became about like this. He asked a young man that was very, he looked like he was pretty well fit. And he said, come up here. Takoja, dechitya huo, de chan, de kaksayo. So in our language, he said, grandson, come up here, break these. Those 7 sticks together, he tried like the Dickens to try to break them. That's what unity is about when you walk with more than one. That's what he said. That's what you have to do if you want to take on this issue. So, and I would say that to you, that, unless you don't unify, it's going to be very difficult to do what you want to do here. Because you're going to be doing something that nobody's done before. In this case, you don't have a treaty. And that's what we have up there is our treaties. So that's kind of like something that it helps support us as we walk. But in this case of here, and mostly it's private lands, the only thing you have to do now is unity, and you need to create the unity. Create that structure that whatever you want to do it and how you want to do it. That's what I think would be something that you need here in order to address that issue, because then you could look at that entity that you just identified, make them be the permitting agency, force them, because the regulation says one of those federal agencies you have to define that. You're going to have to identify that, but you need to organize and say it with one voice.